Welcome to the next in our series of videos from the Wilkes Partnership. I'm Helen Smart. I'm a solicitor in the corporate and commercial team here at Wilkes. Today I'm talking to two of my private client colleagues about matters relating to the Court of Protection and lasting powers of attorney. So we've got Ann-Marie Aston, who is a partner in our private client team, and Sophie Fenn, who's an associate. So Ann-Marie, what is the Court of Protection?
Okay, Helen. Well, the Court of Protection in its current form was established under the Mental Capacity Act 2005, and this heralded a major change in the area of mental capacity law. So the court has jurisdiction to make decisions for persons who lack mental capacity, which could be for something like severe vascular dementia or Alzheimer's disease. It could be as a result of a severe learning disability or particular severe mental health conditions, or indeed somebody suffered a personal injury or accident, so they are unable to make their own decisions. So the Court of Protection then makes decisions concerning someone's property and finances or their healthcare decisions in the event that they can't make them themselves. So the sorts of decisions the court makes can be quite complex ones. For instance, it might be somebody who has a multi-million pound estate and business who hasn't made a will, or they've made a will but it's a long time ago and doesn't reflect their current circumstances. So a statutory will can be made by the court in their best interest, and it can be a large multi-party action. The court also can make decisions on somebody's medical treatment, serious medical treatment, whether that treatment should continue or be withdrawn if the person's unable to make their own decisions. But the vast majority of work that the Court of Protection does is a property and affairs applications to appoint a deputy to manage the person's finances for them where they can't manage it themselves. But you know what the result of that is, because most of the work for the court is these sorts of applications, and there's many thousands of them. It can take many, many months for such an application to go through the court. And as you might imagine, whilst that's going on, very little can be done for the person and their finances during that period, which makes it very stressful for all concerned. So, but you know, not everyone can put in place something to manage a person to manage their affairs. But if it is possible, a well-drafted lasting power of attorney would be the obvious thing to do beforehand, so that you know you don't have to engage with the Court of Protection if at all possible.
And on that point, Sophie, can you explain what a lasting power of attorney is, why you should have one, and what are the sort of downsides of not having one in place?
So a lasting power of attorney is a document whereby you appoint someone or various individuals who can then make decisions on your behalf. There are two types of powers of attorney. One is to do with property and finances, and the other is to do with health and welfare decisions. And as Ann-Marie was saying, if you put in place a lasting power of attorney whilst you have the capacity to do so, it means that should the worst happen, there is a document that can be used, and decisions can continue to be made even though you're not in the position to make them yourself.
And Sophie, what is the Office of the Public Guardian?
So the Office of the Public Guardian is the statutory body that is involved in processing powers of attorney and then supervising attorneys or indeed deputies if they are making decisions on behalf of somebody that lacks mental capacity. So when you come to do a power of attorney, you need to sign it, your attorneys need to sign it, a certificate provider needs to sign it, and then it all needs to be sent off and checked by the Office of the Public Guardian and then stamped and validated. So it's a sort of twofold role that they have. One is to process the document and make sure it's all registered and correct, and the other is ongoing to make sure that people aren't abusing the power that they have for the incapacitated person.
And Anne-Marie, what would you advise if you've got a friend or a relative who appears to lack mental capacity and hasn't got a lasting power of attorney in place?
Well, Helen, the first thing that they need to do is to check the person's mental capacity, because although they may have the onset of something like dementia, with support and explanation, it may be the case that they can make their own decision and put in place a lasting power of attorney. However, if it's clear that they can't make that decision, then a medical professional such as a GP, psychiatrist or social worker would then have to prepare what's called a mental capacity assessment on the Court of Protection's own form to confirm that the person lacks mental capacity either to manage their own affairs or to make certain decisions.
And what's the process for applying to the Court of Protection?
So armed with the medical evidence, for a standard property and finance application to appoint a deputy, then on the court's own forms, full information about that person's finances needs to be evidenced on the forms, their own personal details, the details of the applicant who's applying to be deputy, and also the details of persons who should be notified that a deputy appointment is being applied for. So that's usually close family members, but if there are none, then persons who have an interest or are close to the person who's incapacitated, just so there is opportunity for someone to flag up to the court if they don't think that the deputy is the right person to apply and therefore they can object. But if there's no objections, then when the court receives all the information, they will issue the application, they will direct for the persons to be notified, and then consider the application. Sometimes they may have further queries or questions or requirements which need to be dealt with, but providing there's nothing further they need, they will proceed to appoint the deputy, and once what's called a surety bond is in place. The surety bond is like an insurance policy, so the incapacitated person doesn't lose out if the deputy makes decisions where the person loses out. And once all that's in place, then the court order is issued by the court, and the deputy can start managing the person's affairs. Now, it doesn't end there for the deputy, because every year the Office of the Public Guardian will require an annual report which deals with what the deputy's been doing over the last 12 months. So details of the monies that they've that have come in and what they've gone out, what they've paid for, and any other decisions which they've made on behalf of the incapacitated person. So the court order does set out what their duties and powers of a deputy are, but they also need to be mindful of the Mental Capacity Act and its code of practice, as would be an attorney. But an attorney, unless specifically requested by the Office of the Public Guardian, wouldn't have to ordinarily report like a deputy would.
And Sophie, how has your work been affected by COVID-19?
So Helen, we're obviously not able to see people in the office like we would normally to take instructions for powers of attorney, but we're able to speak to them on the phone or arrange a video conference to talk things through with them. And that's particularly important for people that are acting as attorney themselves, because they might find themselves in quite a difficult situation at the moment with the social distancing restrictions, not knowing how to act as an attorney. So the private client team is still operating, and we've had to alter how we do things. And the Office of the Public Guardian is still open. Powers of attorney are still being registered. It's just taking slightly longer than it would normally.
And Anne-Marie, how about you?
Well, as Sophie says, the private client team is still here. Some of us are in the office, some of us working from home, but we're always contactable over the telephone. In terms of court of protection and deputy applications, they are taking considerably longer than they would normally, and also any sort of hearings that may be listed are now all done on the telephone rather than attended hearings. But if anybody has concerns about somebody who they think lacks capacity and may need to apply to the court, then we're here to provide advice and assistance with that sort of application.
Thank you both so much for talking to me today. Anne-Marie and Sophie's contact details will appear at the end of this video, so feel free to contact them about any of the matters we've discussed today. Thank you very much. Bye-bye.
Okay. Bye.